Welcome to Beyond the Fine Print, the podcast where we help you simplify the ever-evolving world of commercial laws and technology and answer the major questions facing lawyers today. I'm your host, Rory O'Keefe, and in each episode, we'll be breaking through the jargon so you can stay ahead, keep it cool, and take control back. Now let's get started. Hello everyone, welcome to Beyond the Fine Print. Today, we're talking about beasts. Not the mythical ones, although there may be a few lurking in the shadows of a sales team, but the beasts that roam the seven kingdoms of legal ops and lawyers themselves. Now, my guest today is Tom Fleuriot, founder of Flocsam. He's your legal ops whisperer and the slayer of the five beasts. He's very concerned about where I'm going with this, by the way, as he's looking at me. But I've described him myself. He's the Jon Snow of legal transformation. So he's bold, tactical, unafraid to challenge the status quo. So in this episode, we'll be journeying beyond the wall of strategy decks and dashboards to uncover what it takes to conquer these beasts. Now, we're taming risk to forging alliances in the legal and commercial realms. Tom will share his tactical insights that will help you wield influence like a Lannister, navigate tech like a Stark, and execute like a Targaryen. So whether you're drowning in dashboards or stuck in strategy mode, this conversation is packed with takeaways to help you claim the Iron Throne. Okay, honestly, I'll stop there. To translate, this episode is about simplifying legal operations and risk management. It's bridging gaps between legal and commercial thinking and helping all you in-house lawyers out there building trust with your client and using the tech and the tactics to make your life a bit easier. What more could you ask for? Tom, welcome. You're five beast slayer to Beyond the Fine Print. Welcome.
Thank you. And absolute pleasure to be here. And maybe now's the wrong time to mention that I've never actually seen an episode of Game of Thrones in my entire life, but I do understand all of the references. So we're okay.
We're okay. Okay. So I'm just going to cut out that bit anyway. No, it's interesting that when we were first speaking about in advance of this podcast, there was something I'm itching to get you to talk about is your concept of the five beasts. So can you tell us what they are and how can lawyers spot them, or more importantly, spot them in themselves? Yeah,
sure. So look, I mean, it's as much a playful theory as anything else, although it is something that I find quite useful to keep myself in check and myself in balance where possible. And like all good ideas, it's borrowed with pride from something that already exists. And the five beasts is an idea, or the big five is a concept from the African savannah. And originally, it was the five animals that are most difficult to kill, although these days, as we tend to think trophy hunting as a less honourable pastime, we talk about it as the five beasts that are most dangerous to you. So there is a Julia Donaldson book called The Ugly Five, which is about the ugliest animals. There's a little five and there's a big five. And as I read about the big five and was introduced to it by my kids, I realized that each of these animals can act as a metaphor in some ways for what can make lawyers good, but in many ways for what can make in-house lawyers less effective in their roles and in their day-to-day. So the big five are a lion, a leopard, a rhino, a buffalo, and an elephant. In terms of how this sort of symbolizes the lawyers, and I've genuinely thought about writing a book on this, although I'm not sure how far I can stretch the metaphor over enough pages. Starting with the lion in the room is the fairly obvious one, and it's not about the fact that you have a man sitting on a rock while all the women run around doing the work and picking up the meat. It's more about the pride that lawyers naturally bring to the table. And it's something where we are quite rightly delighted at the fact we are lawyers. I think we are proud of our profession. I do believe in the whole potential last defense against tyranny line, even if we don't always necessarily show it. However, where that can be a negative for us and something that damages our ability to act is where our pride in the fact that we are lawyers results in us always looking for a legal solution as the primary solution, or a legal problem as the primary source of a problem. So there's damage caused by us taking that approach. And then there's also the fact that our pride can often make it harder for us as individuals to acknowledge where we are wrong. And sometimes getting a lawyer to climb down from something can be more challenging than getting some other people to climb down. I'm not saying lawyers are unique. all human beings carry the same character flaws at slightly different points across the distribution bell curve. But this is the thing with pride. I think at its best, pride can make us push for a better solution, can push us to make the law better, to provide that robustness to our clients. But at its worst, pride can mean that we are too focused on the law specifically, and it can mean that we are less likely to move into an ideating, collaborative, collegiate mindset or a growth mindset. You know, that idea of like, we are here to learn as much as anything.
So just kind of taking a context that I'm familiar with most is negotiations. So some treat negotiations in a commercial big implementation deal or digital implementation, they treat it as like as an adversarial or a point scoring exercise. And I said, that's the wrong approach. That all that serves is for you to score points. Great. But the result is you're going to draw out the negotiations for no truly valuable reason other than you saying, yeah, I got them to agree something, which if you actually spoke to your own client, your own in-house team, they don't really care about. The other part which I see in the pride context is when you know that the other side has backed themselves into a corner, some people will just keep going to make them look bad because they want to make themselves feel because they know they're right. I'd say it doesn't matter if you know you're right. You're not going to be able to close this contract by belittling or just trying to win those scores. When they're in a corner, you need to try and find a way to help them out of that corner, whatever the point is. And they'll appreciate it because they'll know what you're trying to do. And you're helping them save face. And you might not want to because they might have been absolute you-know-what during the negotiations. But the point is, it's not about you. It's about the deal. It's about the contract. If we want this deal to close, we want to do it fast, we want to do it well, you're going to have to drop some of this line mentality, which you've said is both a strength and a weakness at the same time. That's my take on it.
Yeah. So I think that's absolutely right. And definitely there's also the point of recognizing this mindset is likely to be on the other side. So that whole point about giving them the space to back down is acknowledge that they probably have an element of pride. Now, sometimes in negotiation, I don't know if I'm sure you've done it, it's like you will deliberately expose that pride in the other lawyer. So like if you're negotiating and ideally you've got your commercial people in the room with you, sometimes there will be times where the opportunity is to isolate the lawyer by pulling on that pride and making them overextend. But that's, once you've done that once, like you say, you don't keep backing them down.
That's negotiation strategy. Yeah.
Because there's going to be some problems. I would say that there's another animal happening in that scenario that you've painted, which is the rhinoceros in the room, right? Now, again, the rhinoceros, if we think about a rhinoceros, this is something that is supposed to be solid, it's supposed to be stable, steadfast, that kind of thing. And when we are trying to exhibit these characteristics, that's a positive thing. But what else do we know about it? We know that it can be very short-sighted, and we know that it can be very prone to anger and prone to charge. And I think those are things is, again, by using that rhinoceros concept as a lens upon our own behavior and our own activity, this allows us to say, if I'm in keeping with the contract negotiation context, although I think this can also apply when you are advising or trying to resolve a problem with your in-house clients that is particularly tricky, or you have a tricky client. But it's that, how do I take a step back? How do I look at that bigger picture? Not charge now, either because I need to manage the relationship or because I need to see what the business outcome is that I'm trying to achieve. And so I think you're right. I think there's an element of that pride in the sense of this is all about the legal solution. This is all about making me look good. We want to dampen that down. But it's also I am being short-sighted, either short-sighted as to how I grow this relationship effectively or short-sighted as to the big picture of what I want to achieve. And so I think there's a rhino lens in that scenario you paint as well as a lion lens through which we can look ourselves.
Lovely. So we've got the lion, we've got the rhino. Which one next?
Let's talk about the leopard in the room, right? Okay, so the leopard, I always feel sorry for the leopard, right? Because no one ever talks about leopards. Everyone talks about tigers and lions and that kind of thing. But the real issue with the leopard is a solitary creature. And the one thing we know about leopards is every leopard's coat is different. And there is a tendency in lawyers in some situations where we will deliberately look to make ourselves different because we want to. Now, at our best, this is something we're trained to do, and we should be trained to do. We should be the person who, when 19 people are saying to do the wrong thing, we're doing the right thing. Or when 19 people are blindly panicking and rushing at a problem, we're the ones saying, hold on, guys, let's not freak out and rush into this. Let's be that position of calm. Let's be that sole voice if we have to. So that strength is, again, at its best, a very positive thing. At its worst, it's that whole I'm going to mark this red line up when I don't have to. It's the I must have my own legal tech solution, even though the business has a solution that is good enough for them. I'm special. I don't have to do this training. I don't have to sort of accept these lower standards from other people, when in fact it's not that we're different, other than that we're choosing to be different, if you see what I mean.
Mm-hmm. I do. Okay, so lion, rhino, leopard. We're getting there.
Now, the leopards, and this might sound like I'm being contradictory, but the thing to remember is that these 5 pieces, it's a bit of fun, and it's like tarot cards, right? It is a lens through which you can look at yourself and you can look at your action, and it enriches the metaphor and allows you to stress test yourself. I'm not saying that there's a fundamental truth or an actual creature inside everybody, but it's just something to think, am I pulling these characteristics out in the right way when you're having trouble with the situation? So the leopard's sort of evil twin is the buffalo. And that is the herd mentality. This idea of the buffalo, of the lawyer as a herd animal, is where we are so desperate to be liked, and we are so desperate to be a part of the community and the trusted business advisor, that we start compromising the fundamental values that sit within us as lawyers. This is a really interesting dichotomy, that I see lawyers being difficult and individualistic, the leopard, when they don't need to be. But I also see lawyers then failing to bring out the leopard when they should be, and that's what I'm calling the buffalo. And I think that you can see it in various groupthink examples. I think if we stick on contracting, the way that we talk about indemnities, when you really scratch at it, is a little bit weird, because often there are scenarios where, from a consequence and damages and causation perspective, an indemnity is not needed for certain things, but then lots of lawyers start throwing in. The way we talk about direct and indirect damages, I think, is often, with many lawyers, a bit strange. The way we went about GDPR. GDPR was a great example, or supply chain due diligence when the Bribery Act came in, are great examples of all the lawyers getting this collective insanity and racing towards an overcomplicated solution that fundamentally gummed up the business, damaged the credibility of our profession. And if you scratched at the surface of that and said, why are we all recommending a 32-point checklist here? I'm not sure a single lawyer could have stopped and explained why. So, as with all these other animals, the buffalo can be a positive. Sometimes actually that, can we conform? It allows us to think a little bit more carefully about the tribe and how we protect the tribe as much as anything else. But at its worse, I think it makes us just stampede in a direction without any thought. And so again, I use this concept as a way of checking myself. Am I actually clear enough on why I'm running in this direction and why I'm acting with these people?
I think this way I look at it is, the joker in me is the idea that, lawyers have to herd people, and we usually have to herd the other stakeholders in order to get to a conclusion. So it's a bit like the leopard dealing with the buffalo people. And for those of you, please don't tell your C-suite that I'm calling them a whole series of buffaloes that you have to herd on a regular basis just to get them to the right answer. But there is the other aspect of the herd mentality, which is it's sometimes because as in-house, it is easier to follow the direction of somebody that you trust and you believe, they've thought it through. I get it. Makes sense. Let's do that. Why do we do it? Probably because we just don't have the time to step back and ask, what do we need to do for our company? Because you might be just a 1-2 person team within a 10,000 employee company. You don't have the time to be juggling and have this headspace to ponder the great thinking. But where I ask people to question is when they're writing their playbooks and they're uploading them into their AI tools, and this is the risk profiles that we need to have before we need to escalate, whatever. I sometimes ask people saying, did you test why you're so particular about that clause or that particular answer? Because in each of your negotiations, you've spent 2 hours to 2 weeks trying to convince the other side of a position that maybe we've all forgotten why, because the people that came up with the position have left the company. But we're still running around thinking this is going to be really, really important. We've always had in our playbook, it must be important, therefore I'm going to negotiate it in. And we've all seen ourselves fall into the trap of following the mantra without questioning why. Now, why is it we're so hot on this type of indemnity, but everybody else in the market is telling us nobody cares? And why are you asking? You're an outlier. And we say, as the leopard, we're special and we're the leaders and we're in front. That's why the other people just haven't caught up. And then you ask another year later saying, so, and they go, no, we're spending too much time, and actually we've extended our negotiation timeline by 2 weeks, and we need to cut that down because we're losing business and revenue as a result of having these lengthy negotiations. And legal has been considered as a friction point rather than as a supportive strategic business advisor. So I always think that the buffalo for me is a bit of finding that time, whatever those low-hanging fruits are, but anything that you see is going to slow you down, re-question, is this the right place to be? Should we change the process? Should we change our positions? Should we just get a second opinion again and just reconfirm, yeah, you're totally right, stick with it? That's what I kind of advise people when they're thinking as the buffalo.
So I absolutely agree with the advice. I think also it's really important to stress here that this is a playful metaphor. It's an intentionally playful metaphor. It is being playful with myself and acknowledging my own challenges. And it's not suggesting that there are fundamental failings in everybody. We all exist and are thrown into environments where we have to develop coping mechanisms. And that's even before we get into what we are taught to do, whether we're taught to do it in university or during our training contracts, or whether we're just mostly of certain character types, which is why we went into law in the first place. But I think that the more that you recognize it and acknowledge it and think about when it applies, for example, the scenario you set out with that use of playbooks, that's where we can challenge ourselves gently, but in a way that says, how do I maximize the benefits of this tendency or this behavior?
I get it. I think it's more if you can recognize what you're doing and you're recognizing how you're perhaps being triggered to react in a particular way. Once you can see that happening, you can make a choice. Is this right or not? Like as you said, it might be correct to follow the herd, but at least you're recognizing that's an active choice that you've made yourself.
Exactly that. It's mindfulness, right? It's purposefulness.
You said, I didn't want to say it because everybody's used to hearing that word for so long now. But anyway, mindfulness, we all know it. Yeah.
But this is the thing, is that a lot of these words, this is the thing, right? Most words and most cliches actually came about for a reason, and then they slowly get subverted by misuse or overuse or whatever.
Yeah.
But actually, sometimes those words still bring value. Sometimes cliches still bring value, right?
I'm sold. Yep. But we still have the big elephant in the room here.
Well, actually, so the elephant in the room, this is the reason I left it to last, but it's quite a nice segue from the scenario that you set out of the lawyer who is blindly accepting the policy. And the elephant in the room is that a large amount of lawyers have a gap between the level of their understanding of the law itself and the extent to which they are willing to admit that level of understanding. And this is something we need to talk about as a profession. So I am not saying that I have an immaculate understanding of the law. And in fact, many people I've worked with will say that I have a terrible understanding of the law. But I'm generally, I hope, fairly good at saying I don't know the answer and I'm not going to shut my eyes and guess. And it feels to me that I used to work in a global role, right, where I would have to pull in information from legal advisors, whether external or mostly internal, and we'd have to aggregate legal interpretation from multiple countries and try and package up and send it out. And unfortunately, what we often found is we would receive very clear assertions as to the legal requirement from a local lawyer where our research while we were waiting for them or previous advice we'd received would be completely contradictory to that advice. And when we went back and said, are you sure because I understand this, the quality of the assertiveness would melt away. I'm not saying this is happening all of the time, and I'm not attacking it in any one direction. And I understand why we create this myth around ourselves. We find it hard to say we don't know. Even though it's ironic, because I think the very best lawyers are excellent at saying, I don't know the answer, but you know I'm going to get the answer quicker than anybody else, so let's go. But we do have this thing happening that can lead to one of two potential outcomes, particularly for in-house lawyers. Outcome number one is that because we don't understand the law properly, we produce an over-conservative assessment and an over-conservative solution, and that gums up the business when we didn't need to. And when I say understanding the law, I don't mean just understanding the legislation. I mean understanding how the legislation is applied, who's applying the legislation, how it can get enforced, all these kind of elements. And then scenario number 2 is the opposite, is where you get lawyers who don't understand the law enough to know that there's a risk or a danger or that they should stop and ask questions. And then that's what results in the over reckless solutions, where the lawyers say, yeah, just go on, just fill your boot. And the company racing forwards and the lawyer feeling very good because they've got involved in the herd of the company and they're pushing for a result and they're a collaborative lawyer and their pride is up and they're different from all the other lawyers because they're allowing the solutions to happen. And the truth is they just never understood the requirements in the first place. I think as a profession, we need to get better at saying it is fine to articulate that the law can be complex. It's fine to articulate that we need some time to pin it down, even if that is not me saying we need to be able to recite chapter and verse of the Companies Act.
There's a lot to digest in what you've said there, and there's a lot of truth. I agree with you. I think that the idea of the elephant for me is I always see it as a sign of wisdom when people say, not sure what the answer is right now, let me check. And the reason why I was impressed with it, because I don't think it applies just to lawyers. I've seen many in the C-suite who they're there for a reason. They've specific specialties and skill sets. That means that's why they're on the board or they're in the management leadership meetings. But they know their limitations. And knowing your limitations is also a sign of a good lawyer. It's the same for doctors, the same for accountants, the same for any profession
Absolutely.
Out there to say, I don't know, but give me some time to check. Because if you knew all the law, well, then that'd be pretty dull. But the point is, I think it's very damaging to a company, especially like as an example, startups and scale-ups, for example. They'll bring in a lawyer. The lawyer is also excited. They're built on equity. They're not getting paid, but they're invested in the success of the company. And then what I kind of say, I use in different phrases in different ways, but I say you go native, which means that you've removed your objectivity, which you need in order to be an effective advisor. You've removed that and you've allowed the hype and the story and cloud your better judgment when you're delivering advice. And you can't be some people say, oh, we're the police force. I said, no, you're not. I said, so we're the teachers.
Yeah,
we're
definitely never police force, never babysitter, never, absolutely.
No, you're a business partner. That's what I feel. You're a strategic advisor and you give the advice and the advice will be taken, whichever way it's taken, by the people that are making the ultimate decisions. Okay, unless you're in a law firm, but then it's you. But when you're in-house, you must remind yourself that you're not there to stop things from happening. You're there to provide a solution, but you're also there to ensure that, if somebody comes up with a question that said, like I did 6 years in criminal law, so I can answer a few questions in criminal law. Great. But that was a while ago. So I'm not going to sit down and tell you about the ins and outs of criminal law today because I don't. Now, there'll be other people who would say, oh, well, it's employment law and I'm working in a tech company. So employment law comes up a lot. I do a lot of outsourcing agreements. Therefore, I know a lot on TUPE. That's great. But then they ask you questions about vetting and background checks and employee disciplinary matters and Equality Act. Are you sure you know what the latest is? Because there's a reason why those books are so big. And then you get another question, which is on tax. Don't talk to me about the size of that book. And it's so nuanced that you really need to say, as an in-house lawyer, no, I'm going to get external counsel or I'm going to get somebody in because it's going to be a big requirement. So we'll add to our legal team in order to affect that. And having the wisdom to know where your limitations lie, I think is extremely important.
Absolutely. And I'm not suggesting that you should be doing that every time, right, and getting chapter and verse on everything. TUPE, though, I think is a very good example where I remember once a lawyer insisting that there must be TUPE in a set of contracts and me saying, well, no, on any reasonable reading of the TUPE provisions, there's no way TUPE is going to apply in this context. This was me disagreeing with a lawyer on my side where it was a blocker. I was like, this is you not understanding the law. So I would say the scenario you described of going native, I'd say that's a blend of two of these metaphors or symbols. You've got the elephant where you are blinding yourself as to your lack of legal understanding to get a result. And you've also got the buffalo happening because you're trying to run with the company. You also got the elephant can combine with the leopard, where your ignorance as to law and your desire to be different and to show that you stand out, and then your pride, your lion as a lawyer, saying, I am a lawyer, and the lawyer's position is different to the company's. Actually, that elephant in the room pulls you in the opposite direction, where you become the blocker, you become the person with the police officer or the babysitter mindset. So the elephant can cause very different challenges, and it's a very rich tapestry. Well, the savannah is a circle of life, right? So there's all kinds of stuff happening there. But I think acknowledging that, where do I not know enough to make the call here? Sometimes it's okay to not know enough because you know enough about the boundaries of consequence. But there are other times where you're operating in such position of ignorance, you need to sense check a little bit, even if it's sending 8 bullet points to external counsel and saying, am I a moron? What have I missed? And turning it into a 10-minute mate's favor instruction. It's like knowing when you need to do that, knowing when you need to step back.
Yeah, I think for just an aside point, I think for those who are just the single in-house counsel of a company, the one thing that I remember I did that once I was working in arbitration and it was going on for 2 years. I was the only lawyer in this engineering company. And after a while, it gets a bit lonely because you don't have people to test your thinking with. Mm-hmm. And after a while, because of that, you're reliant on the things that you get from law firms, their updates, their articles, the latest laws, the horizon tracking type information. But you're always wondering, but am I missing something else? Is there something else I need to know about? So you feel more reliant on other people. I always think that if you have that one friend that you can pick up a call without breaching confidentiality to everybody listening, but you have that one friend that you can call just to say, I'm on right track, aren't I? And they're confident enough to be that phone a friend person that won't let you down. And they'll say, yeah, but have you thought about, and you go, oh, of course, yes, I remember that again. Yeah, that's great. Thank you very much. And then you go back on track. Having just those light conversations is enough, I think, for a lot of people, because like your conversation with your colleague to say, do you really think 2P applies here? Test me, because I don't think they do. So we'll have the conversation, we work it through, and then we realize, no, I still believe 2P doesn't apply because of these reasons. And then they're brought through that thinking process. That's a very valuable conversation that will sit and stay with those people a lot longer. So I always say for people, don't be afraid to ask questions. Don't be afraid to check your thinking. That was the mantra a few years ago. Just don't be afraid, because the risk of getting it wrong is bigger to the company.
Absolutely. Absolutely. But I'd also say, and I appreciate that you're focused more on that sort of like sole counsel element. So even in a multinational, it's the same principle. I had people where for certain legal matters, I knew I could pick up the phone to some of my colleagues and they'd give me a sensible assessment of the law. And by the law, I mean the law and how it would be applied in that relevant context. Because if you don't have the relevant context, you're not understanding the law. But I had some other colleagues where I wouldn't ask them questions about certain laws because I didn't trust the elephant in them. I didn't trust their ability to accurately.
Do you want to name a few names? Anybody?
I'm not going to name anybody, and I'm fully willing to accept that some of them may have had me on that list as well. I remember one instance where there was a French supplier that was on the cusp of bankruptcy, and this was early in my career, and I fairly confidently looked at it and said, "Oh yeah, we can do X, Y, Z." And then I casually mentioned it to my boss in a catch-up that was happening, fortunately, the same day. And he said to me, oh, no, French laws around how you interact with potentially bankrupt companies are more consequential than in England. I just didn't have a clue. And actually, this was me getting overconfident in my ability to assert areas of the law. And it was a great lesson for me.
Yeah, I enjoy working with other jurisdictions. You really do learn that it's not all the same.
But remembering to ask, right? Remembering to not get overconfident, even though I do think the leopard in the lawyers that is saying, no, my jurisdiction is so special and so unique. I think we can challenge that a little bit. But I think also understanding that there are differences is also really important.
Just stay curious. Okay, keep learning, stay curious, ask the questions.
Exactly. This is, it's like I said, it's like some of the cliches exist for a reason, right? Growth mindset, stay curious, keep learning, keep an open mind. Don't wrap your personality up in your answers or your ideas. It's all,
Keep calm, move on, yeah.
No, I think I mean, I'm happy with that one as well, but I'm not sure that's quite the point we're making.
Yeah, well, I'm just throwing out cliches while we're here.
And let's do it. Just do it.
All right. So we slayed the beasts for now. I'm sure they'll re-emerge, but we slayed the beasts. Let me move on to another topic, right? So because we have different approaches when it comes to this thinking around lawyers thinking like business people. So I'm not saying that we're different, it's just that we attack it slightly differently. But I'm very interested. Nobody wants to hear what I have to say, so I want to hear what you have to say. So how can in-house counsel bridge the gap between the technical legal knowledge, which they're automatically assume they have it, no matter what level they're at? If you're 1 year qualified to 100 year qualified, every person who's not a lawyer will expect you to have all the knowledge. All right, so that's the first thing. But bridging the gap between that demand and having commercial fluency, I'm just interested to hear what you have to say, because I was thinking about, you said something about the Companies Act, and I was saying, well, if you're quoting the Companies Act in a budget meeting, it's like bringing a thesaurus to a knife fight.
Yes.
What are you doing?
Although a thick enough thesaurus could be quite useful in a knife fight. But yes, I think the analogy is right.
Depends. Yeah. So, but I'm just curious, what are your thoughts about how in-house counsel can bridge that gap?
It all comes back to this. What is the outcome that we're trying to achieve? And this is something where I do feel that often one of the big challenges with lawyers is that we haven't pinned down enough clarity as to that target outcome. You bridge the gap by moving towards the business language, but you also bridge the gap by addressing some of the animals in the room. So you stop seeing legal as the sole solution. So you kill the lion a little bit. You stop seeing your language as special and unique. So you kill the leopard a little bit. You lift your head up to look at those business outcomes, so you kill the rhino a bit, and you make sure that you have a strong enough understanding of the law that you can explain it without having to refer to it. Because ultimately, if you can't explain stuff in 20 seconds, it's usually a sign you don't understand it. So you need to be honest with yourself, where if you're being dragged down into the technical, it's like, do I really get the law, or am I trying to parrot it out and push it out? So, yeah,
That's great. But I just need to add a disclaimer here that no animals were hurt in the making of this podcast.
Nor the prep.
But you did point to risk. So I'd be interested to hear, because in your role today, you're acting as that consultant who helps lawyers start working through how to see risk, how to manage risk, and how to be better at this, rather than trying to do everything all at once, which we know even from your New Year's resolutions, it never happens. So, and some people will treat risk like it's radioactive, others will treat it like it's optional, and then somewhere in the middle where it's, from my view, it's competence. But I'm interested to see, what are you seeing, or what can you tell us about common mistakes lawyers are making when they're assessing and managing their legal risk?
I think there's a few challenges here, and just to sort of talk a little bit about my background, I spent 8 years before I became a lawyer working with the pricing and project cost management for fairly complex contracts, right, in the engineering world, including things like tendering and the like. So I would have to evaluate risk, price up risk, articulate risk, and I also ran our business unit risk registers and things like that. So I wouldn't badge myself as a risk professional. There's a whole gang out there that it's a very complex world, and I can't even pretend to scratch the surface on all the quantitative stuff or anything on those lines. However, I do feel quite strongly that when we talk about risk, we have to start from the ISO standard, which is that risk is the effect of uncertainty on an objective. So you need to know the objective before you can talk risk. That's principle number one. Second of all, if you're talking about risk, you need to be talking about it in a coherent form. And there's lots of aspects where if we have a structured approach to risk, our structure is not helping us to have a conversation effectively. So one anecdotal example, I was at a popular in-house conference last year, and I was sat with a notepad because I was still trying to work out, do I want to start trying to take on this conversation about risk with in-house lawyers? And the word risk was used in literally every single presentation and talk that I went to. Lawyers said the word risk. And I think in many instances, they used it in limiting ways. One limitation, is that lawyers say there is a risk when they actually mean there's a requirement. A second limitation is that people use the word risk for the wrong reasons. And by the wrong reasons, I mean they might use it to push a decision on, to justify further analysis because we're scared. They might use it because we're murky and we haven't dug down deep enough to understand what's actually needed. To my mind, there is a simple 4-point mantra as to why we should be thinking about and articulating risk. And every time we do it, we should be doing it to help the company to understand reality, decide what to do, act appropriately, and remember why it's acting. And if you are not talking about risk to achieve those 4 outcomes, you are almost certainly either misusing risk or using it with the right intention, but misunderstanding that risk. There's also a test that you can apply to see whether you're successfully articulating it.
Go on.
So if we think about where does risk get written, it's broadly written in 3 places. You can say that it's written in the form of a memo or an email. You can say that it is written in a risk register if you're the kind of company that has risk registers, or you can say that it is written in a board minutes or something capturing a decision, right? Those are broadly the 3 spaces. You don't tend to write about risk in a policy or a process, for example. You can do, but you generally won't. Whenever that risk is written down, in order to see whether you are hitting those 4 requirements, understand, decide, act, remember, I think it is always worth asking, first of all, will somebody reading this understand what's happening in 2 minutes? The next question is, will they within 4 minutes of looking at this start proposing solutions? Your next question is, should at least 6 people in the company be aware of this articulation of the risk and the outcome from the fact we're discussing it? Because if it's fewer than 6 people, is this actually a risk or is it just a bump in the road that I need to resolve? And I can brag about, but we don't need to bother many people with. And then your last question in terms of how it's written down is what I call the horizon test, which is in 8 years' time, if the hostile actor is looking back at what I've written here, will what I've written here be something that successfully captures what we were taking into account at the time? And I'm not talking about an essay, right? I'm not talking about a 5-page memo or even a 1-pager, but I'm saying, is there a way that the sentences that I am producing here or the single sentence I'm producing here will be misleading if somebody is looking for a smoking gun? Because for all that, we quite proudly carry privilege, we don't always have privilege. Sometimes privilege gets waived, that kind of thing. So 2, 4, 6, 8. Understand in 2, offer solutions in 4, share with 6 people, be comfortable with what I've said in 8 years' time.
The only question I had is, in any job these days, is anybody going to be there in 8 years' time? Possibly
not, right? But I think the reason I ask the 8-year test, I mean, obviously, in terms of the first 4-point test of understand, decide, act, remember. Obviously, you want people to remember all the time because, as the example you used of the playbook earlier is a great example, right, of where you forget why you're doing things. So you might have an issue that the playbook was structured badly in the first place because people weren't thinking right, or we're looking for legal solutions over non-legal solutions to deal with certain risks, that kind of thing. But it also might be that you haven't successfully captured somewhere the basis for it, so the company does not have an ongoing reason for fighting for this part of the playbook. And without an ongoing reason to fight for this part of the playbook, it just becomes that it's our policy, which any seasoned negotiator can work around in various levels of pithiness and condescension, right? Whenever you hear it from the other side. So you can always work through it. So the reason I say 8 years is there's 2 reasons. First of all, I've already got 2, 4, 6, so 8 is the obvious next number. But second of all, it's about it being sufficiently distant that someone can't explain it. That you can't sit and say, no, that's not what it meant. Right? Because we are talking about a scenario where a hostile actor, like in a court case or in a discovery exercise or in a public inquiry, that they're reading your words there. So that's why you ask the 8 years test, is to get your mindset in there is sufficient distance between what I'm writing and my ability to offer additional articulation of the reasoning.
This is very interesting. It's a very different way of attacking the issue. I'm trying to avoid the word risk now that you've said it. I'm going to have to take out a thesaurus and start working my way through.
It's fine to misuse the word risk as well.
Is it?
I do it myself.
Okay, that's fine. Because I know everybody listening would be going, what do I use instead? Copilot or Gemini, tell me what I'm supposed to use instead of risk. But it did draw me to an idea around the technology that we're now employing in order to make these assessments, to formulate this thinking in the right way. And if we did follow the approach you've said, do you think there's something out there that you're seeing in-house teams using, or are they drowning in dashboards? Like, if I hear one more platform promising to revolutionize my workflow, I might just go back to using the fax machine. And anybody who knows me, they know that I've been, for the last 15 years, trying to get fax machines removed out of notice provisions in contracts. And I know somebody's going to tell me, but we need it in certain regulatory aspects. Yeah, I know. But do you know where it is in your room? And I say, do you know what the generation's coming through? They don't know what it's like. They also don't know what the sound is. And they also don't know the special paper you need for the fax machines. Okay, I'm reminiscing now. Okay.
No, but it's an important point about notice clauses, right? I'm pretty sure there are some contracts in my former employer where I am a named individual on the notice clause, and I have no idea what they're doing with that mail. I hope that they've successfully removed it. Right?
Well, you see, they don't need the notice clause if everything goes well. Okay, that's what yes. I tell people. Nobody opens a contract if all goes well. Okay.
Yeah, so what's wrong with notice periods at law? Like, why do we need our special notices?
Because we're special. Okay.
Yeah. So I didn't notice periods, but notice methods. Sort of service
yes.
methods.
Yes. No, but just on the tech, and just because that does link quite well to trying to find solutions to resolve things a little bit faster for ourselves, and just because what's out there, like where are you thinking, or what are you seeing from your practice around that?
This is the thing. So I was talking to somebody yesterday, and so I launched Flocsam, where I am not, strictly speaking, a technology consultant. I am happy to advise on how to do better technology RFPs, because I think often our RFPs are just an exercise in bureaucracy and pain for every party involved and don't really move the needle. And I also offer to help with framing pilots so you get real incisive clarity as to why you're doing the pilot. In terms of the other stuff, the change management, the project management, the implementation, there are people out there that are better and more expert and more excited by doing that stuff than I am. I really think that what I hope I can bring with Flocsam are structures, but structures that bring fresh ways of looking at and testing these questions so that the answers we come up with neither remain as bullet points on a piece of A2 paper torn off a flip chart, nor disappear into the consultant's arsenal, but instead of being housed in the wrong place, they sit within the souls of the legal team and the company as well. What do I mean on this in the context of tech? Well, so for example, I was at Legal Tech Talk and I asked a similar question to several of these AI tools. And these people are very slick. And a lot of them run a demo that says something like, we assess the contract risk and we give something back on contract risk. And obviously, because these guys are not idiots, right? They're very clever people with wonderful visions and goals for our profession. And they're saying you can do this in one of two ways. You can either take our sample of like what a classic risk profile is, or you can add your documentation in there, and then that pulls out the risk critical, and then you run the test, and it pops out something and it says red, amber, green, and all this kind of stuff. The issue is that the baseline for how we consider risk, the aggregated sense of human endeavor that is feeding this probability engine that then spits out content, is in itself flawed as a starting point. That is before we get into the point of like, I don't think risk should ever be discussed in red, amber, green, because people see red and they think stop, and people see amber and they think and they see green and they think go. Whereas while I'm a big believer in using color to signify levels of fear and levels of attention that would be warranted, in the risk models that I use, we make it very clear that sometimes you're in the hottest area and you might decide to proceed with appropriate actions. And sometimes you might be in the lightest, calmest area and say, well, actually, we might as well take an action on this because that still changes things. It still moves the needle, or it still facilitates stuff. And I think Amber Green stops that grown-up conversation where we're trying to weigh the risk. But then even if they say, well, that's fine, just color code my AI tool, it's still saying that there is such a thing as a legal risk. Whereas I think that if a risk is the effect of uncertainty on objectives, and the objective of a company can only be decided by the company, And our role as lawyers is, among several other things, to act in the company's best interests, in our client's best interests. And unless we really believe that we are sort of platonic guardians who can see more of the world than any other human being, unless we're really going to let that lion sit high in our pride, we have to acknowledge that the best determinant of the client's interests must be a fully informed client. You add all of this together and you say, I don't want a tool that tells me how the risk profile sits based on how lawyers have always been saying the risk profile sits, because the lawyers have not been looking at the right objective when producing that statement in the past. And I'm not saying all lawyers, right? And I do think that at the individual decision level, you tend to see lawyers making incredible agile decisions that blend the immediacy and the business need and what is sensible. I think at an individual level, I think many of us can do that. But in the same way that in Men in Black, they say a person is clever, people are stupid, I think we can say that the sum of the five beasts has resulted in our profession building things that are possibly as harmful to our ability to service our client as they are beneficial. Am I being a bit abstract, or does this make sense?
Well, I'll let the listeners decide for themselves, because they'll take it. To me, it's, there's a nice little sidestep to that question. You see, I ask the questions. You don't ask me questions. What the hell?
Oh, sorry, sir.
No, but it's no, you're good. You're good. The interesting thing about this is that it draws up there's so much hype around the technology out there. I'm not just talking about AI, but just technology we use as lawyers. And in-house teams are being pushed and pressed to use more to basically, and they're looking at their costs and their bottom lines, and they're trying to use the tools in order to justify, in order to save time, in order to do their work more efficiently. And I always say, well, that's automation. That's okay. When you bring in AI as a concept and you're relying on data that's been fed into the tool, which you're then relying without analysis, I think that's dangerous. You always, as a lawyer, will have to analyze the result. I've said it a few times that the AI tech myself, I'm a big user of it, and I applaud all the ingenuity that's there. But I also say that it's only as good as the data. And I think there was one report that came out and it's described AI as a skyscraper on a data quicksand, because the data's out of date as soon as it's uploaded. So the lawyers that you're using to provide the answer or to drive a way of thinking is only that which could be a generalized view, rather than the view which is applied against what you said, the objective. It's a bit like going back to first principles in law school or in university. You have the facts, you get the law, you apply the law to the facts, and you come to a conclusion. And I don't think AI is there. I don't think technology is there to allow for that analysis and conclusion to the right standard and quality that we as lawyers are there to provide.
Well, no, so I'm right there with you. I think one provocative build is, I'd say maybe part of the reason it's not there is because lawyers have moved, because of necessity and because of pressure, we move so far away from that basic pattern that you've just described that we no longer carry inside ourselves the muscle memory to do it at speed, because we've forgotten that that's the process by which we can act best. And then that feeds into this tech. And look, I don't want your editor's whim here, right? Because I do not want this to be me saying that the tech is bad or you can't use the tech. And I think that if you're an in-house legal team, the pragmatic steps you take are, step one, you pick the scope of your action and look for the smallest impactful step. So it's not a small step for a pilot where you're failing to have impact, because if you're failing to have impact, you reduce the pressure to produce genuine learning and to come up with genuinely innovative solutions. And the way you decide that impact is not by looking at legal function metrics. You look at the business outcomes you need to achieve. And you're looking for impact in the next 2 to 3 months because you want it to be a true pilot. You don't want it to be a meandering pilot where you have no volume whatsoever. And then 6 months later, you look back and say, oh yeah, we forgot to do that. So you pick your scope first. You then get a clear understanding of the actual risks, looking absolutely with a legal lens as to the provenance of the risk, because that's the stuff your action is going to be impacting. So when I say provenance, I mean regulations, I mean potential contractual positions, tortious liabilities, whatever. But you also look for solutions that are not solely legal solutions. So, for example, rejection and acceptance clauses, if you're talking about the shipment of goods or the release of services, well, actually, the best way to manage that is often the speed with which you actually reject and accept. It's not about the piece of paper, right? Because it's not about a 3-year litigation. So you have that conversation. Then when you've got your scope of the pilot, you've got the actions you want to take to try to produce something radical, and you've got the right owners and alignment of a small operational cross-functional team for that pilot. That's where I think you can test the tech. But I'm seeing a lot of people, we've had this movement in the last 2 years from this tech is wonderful, use it loads. We've now had this small steps to test. The thing that I am trying to add to that message is that small step has to still be something that is significant enough that there is benefit and skin in the game. And this is particularly important for legal teams where you don't have budget. I set up Flocsam deliberately to say, how do we stop this from being a 100 grand proposal? How do we make this a much smaller value proposal, but with benefits shown so quickly that you've got your business case for the next one?
So what I take away from that is that, again, we don't need to focus on the projects that aren't linked to the strategy, the objective, the business outcome that we need to align with. I do see that even in my career, I have focused myself, even I've made decisions to introduce changes which are great for the team and was useful for the team, but didn't necessarily add anything when it came to servicing the internal client. Now, I can come up with many arguments. I'm sure I can make up arguments by saying, well, a happier team is a more productive team, teams. And you can create whichever way you want. But from the cold face, stepping back, you say, was there something else I could have been doing? It may not be as exciting. It may not get all the kudos and the recognition. But if you take a 2 to 3 month period where you've actually turned the dial to support legal, which in turn supports the business, and you become even closer, a closer partner, getting into that door, into that seat at the big table is where they expect you to be, because they, as much as they might applaud you for all the other bits and pieces that you did, you need to show the value. It's a bit like, I like those legal teams that they change themselves before they're changed by someone else in the business. And I mean that, but it could be budget, it could be cost, it could be, payroll numbers, etc. But if you can come to the business team or the CFO and say, so this is what we've done to realign with your strategy. We have introduced these new things. They're small but incremental changes across our team, which has resulted in this result for you. For me, if I was the recipient of that, the CFO will be going, okay, you get it. You're part of us. You're on the same path that we're on, and you're seeking to do changes to align with our ambition, rather than going it alone, thinking that these things are more important than what we're trying to achieve. So I remember there was one company, they were telling me they had brought in a new service line, and the legal team were just going to absorb the workload. And the general counsels took a step back saying, no, I need to create a new line for legal, new touch points. And then we need to educate them on this new service line. We need to bring in new thinking, new templates, because the services aren't like for like. Like an example we had was in security and cybersecurity. In some instances, you're allowing or instructing a third party to hack your systems to test to see is it robust and effective. Hacking is a criminal offense. You're going to need a consent from the other party to say, I can hack your systems. Obviously, very carefully done within parameters. But you're effectively, you need to think, so the risk profile, all of those things need to be considered again to come up with the right template that when you go to market to sell it, that the market goes, yeah, that's fair. And so that's what she did, which I thought was very effective. And it meant that when it came to, budget conversations and cost conversations, so why did you have extra cost to do these projects? I said, because it was your new service line, which we were ensuring that our team was ready on the ground to pick up all this work as soon as it comes in. And we had tested our positions each and every time to ensure that we would be able to do so. And I found that to me is an effective GC. And And she's gone on to dizzy heights at this point. No doubt forgotten all about me in the process. But I did tell her I can make her, if she ever needs somebody to make teas and coffees for her.
How could she ever forget that?
Oh, you can hear the violins playing. Now I just want to, on this note, right, I would just want to ask you, as I ask all my guests, what's one thing about your work that people always get wrong?
This is a difficult thing for me to answer because I'm deliberately trying to push radical solutions. And I think now is the time for those radical solutions to be pushed. So there's a few things that people get wrong. If I was only allowed to pick one thing, I would say it's the assumption, both from prospective clients and from people that are trying in a well-meaning way to offer me advice, that because I'm a consultant, the basic model is land and expand. So it's the idea that I will go in, I'll dangle a little bit of a thing, maybe even do a free consultation for a day, and lo and behold, I produce a report that says what you really need is me for another 2 months. And at the end of the 2 months, I say, what a wonderful piece of work we did. And the conclusion from that work is you need me for 12 months, et cetera, et cetera, et cetera. And with Flocsam, I'm deliberately trying to build a model where, of course, I would hope to be asked back at certain times. But I'm trying to go for the opposite. I'm trying to say it is better to produce a teeny tiny step in 2 days that the in-house legal team can own and execute and test for the next 2 months, and then decide whether they want me to help them scale or evolve that, than for me to sell 1 day's worth of work in order to get 3 months out of them later. It doesn't excite me. Right. Whereas what really excites me is the idea of all of the change managers and project managers and tech implementation teams and outsource providers. They can go and support in-house teams where the in-house teams choose to do so. But what excites me is every in-house legal team having me help them to find that sharpness as to what they really want so that they can own that sharpness.
Okay, right. Well, my second question I asked, that I'll let everybody listener to decide your takeaways from the comments. I don't tend to pass comment on it, but I do.
You can tell me it's nonsense if you think.
I do like it. I do like it because you're trying to be a disruptor, and I really applaud disruptors. But anyway, we'll fingers crossed, everybody else agrees. But what's one thing that's fun about your work? What do you really enjoy?
It's really rewarding when I see in-house lawyers that are in the position that I often found myself in, because even when you're in a multinational, you are so often on your own, whether because of your seniority or because you simply are a one-person head of country, head of support for a specific department or whatever. And seeing that they're so consumed, quite understandably, with delivering a solution and delivering the best possible support they can for the business, and they haven't been able to take a step back. And I had a conversation with someone yesterday where they're having real trouble with their contract playbook and with their contract management tool. So 2 separate problems. And when I sat down with them and said, have you considered looking at it from this fundamentally different angle, so slicing it in a different way, and seeing the light in her eyes of like, of course this is going to unlock it. It's really satisfying, because for all that we opened this conversation with me teasing lawyers and saying we're effectively big brutes that need to be shot and hunted down, I'm so proud that I became a lawyer late in life. And I'm so proud of our commitment to integrity and upholding the rule of law and all this stuff. And I want us to be the most dynamic, agile advisors in the room. So when you bring that to people and help them to say, this is going to fly with the client, that's a fantastic feeling, particularly when it turns into real concrete change.
No, that's a really, really nice and positive note to end on. Thank you very much for that. So big thanks to Tom for helping us tame the beasts, rethink the roadmap, and remind us that
I think these days I don't think you even cage them. I think it's more about releasing them into their natural environment in a way that minimizes harm to themselves and to humanity.
Well, yes, true. I do want to thank you, though, for all this, because you have changed and hopefully have given people a lot of food for thought. It's definitely something I will walk away with myself. Thank you for this. And until next time, stay curious, stay tactical, and step boldly beyond the fine print. Thanks. Thanks for listening to Beyond the Fine Print. If you've enjoyed the show, be sure to subscribe on your favorite podcast platform so you don't miss the next episode. And if you have any burning questions you want us to cover in a future episode, send them to beyondthefineprint@rmoklegal.com. See you next time.